Good morning all. We're here for an appeal hearing in the matter of CA 011-2018 before Chief Justice Zaki Azmi, His Excellency Justice Shamlan and Sawalehi, and Justice Sir Jeremy Cooke. The claimant is represented by Onoma, lead counsel is Jonathan Fisher QC, and the defendant is represented by Clifford Chance, lead counsel is Annalise Day QC.
Yeah. Mr. Fisher.
Yes, may it please the court.
You have to bear with us. We are going to be struggling with this new contraption in front of us. And I hear that you went through some problem this morning.
May I say, Rana, I'm so relieved to hear you say that, because we've come in this morning. I'm afraid that for my part, I'm still one of the dinosaurs that has worked on paper. But I thought that our cross-referencing had worked out, but we've discovered this morning, in fact, that our cross-referencing isn't exactly the same. So I think...
Never mind, we'll bear with you, don't worry.
Do our best.
Don't worry. Just
Thank you. Thank you. This is an appeal brought by leave of Justice Roger Giles, granted on the 28th of August of last year, on the ground that the subject matter of the appeal involves a matter of general importance, and there's a compelling reason why the appeal should be heard. And the issue of general importance relates to the scope of the court's powers to add a party as an additional defendant to a claim brought by a non-P.J.S.C establishment party, and in what circumstances. And the reason the matter is compelling, we would submit, is because it touches and concerns the ability of the court to bring all disputant parties before the court in order to adjudicate upon the matter justly and fairly in circumstances where one or more of the disputant parties is based abroad. And the key provision that the court will be considering is the application of Rule 20.7 of the Rules of Court in these circumstances. And with the court's permission, I was proposing to develop our submissions in the following way. I was proposing to say a few words about the background to the matter, the background to this litigation, with an explanation of how this issue of the appeal has come to arise. Then, to look at Rule 20.7 and the context in which it is set, to then look at the learned justice's judgment in the court below and identify the respects in which we say, respectfully, the judge fell into error and which form the basis of our grant of appeal, and within that to develop our submissions. So, in terms of a roadmap, the court's permission hopefully will permit me to proceed in that way with that order. The nature of the claim, we say, is very neatly summarised in the claim form, which we have at the electronic bundle reference 001678. And I wonder if I can take you, please, to that document. And so, I don't know if the court has found the document. I'm on the third page into this document, where brief details of the claim are set out. If any of the court is working on the hard copy, I can give the hard copy reference much more easily.
Why don't you give those then?
Thank you. So I'm in the second file at page 299, which is under tab 20. And so it's the brief details of the claim that I was going to refer to in summary form, so that the court can appreciate immediately what the case is about. The claimants are 24% shareholders in the Lebanese Canadian Bank, which went into liquidation in 2011 as a result of an action taken by the US government following findings that the bank had been involved in money laundering and terrorist financing. The findings really focused on a FinCEN notice that was issued by the American authorities on the 10th of February 2011. The defendant in this case, the auditors of the bank and its subsidiary bank, and the defendant as auditors also auditor of a subsidiary called Fadl, which is mentioned in the pleadings. And the claim against the defendant is for losses suffered as a result of the liquidation of the bank and fines imposed on the bank by the US authorities, and losses suffered as a result of the activities of the bank and Fadl, which the defendant failed to bring to the attention of the claimants. And the significance of the party to be joined is that he is the audit partner of the defendant, who was responsible for the conduct of the audit, and therefore was centrally featured in the way in which matters were conducted, and we say should have been conducted. And the allegation, as appears in the fourth paragraph of the brief details of the claim, is that together the defendant with the additional party seeking to be added, who at this stage of the claims form was also added as a second defendant, had acted deceitfully and also negligently. And that's how the claim is to be summarised. The value of the claim, as you can see, was put at $128 million. And the law governing the dispute and giving rise to the jurisdiction of the courts are set out there. And the law being the IFC law, Lebanese law, and also insofar as the jurisdiction of the court is concerned, references to Article 5A1A and 5A1E of the law number 12 of 2004, which we will of course be looking at in some detail. The point to take from this is that in terms of the chronology, the claim form was issued against a firm of accountants, DTME, Deloitte, and Middle East, and also against Mr. Fadl as the second defendant. And that, as it were, set the scene for the case. The case against the defendant, the first defendant, it is very simply put that it's liable in this court for the wrongdoing in the conduct of the LCB audits, liable on the basis that the audits were performed by one of its branches, Deloitte Lebanon, which to all intents and purposes was acting under DTME's direction, and following an unsuccessful attempt by DTME to strike the claim out and obtain summary judgment, today the case is cast against DTME on the basis that Deloitte Lebanon was always acting as DTME's agent, and that DTME is liable for Deloitte Lebanon's wrongdoing, and also on the basis of vicarious liability. The case against Mr. Fadl has always been that he was the general manager of Deloitte Lebanon, partner in DTME, and more to the point that he's liable as a tortfeasor for his actions in the unacceptable way in which the LCB audits were conducted. And the allegation is made with reference to Mr. Fadl's failure to perform anti-money laundering and counter-terrorist financing obligations of both the domestic and international nature, which rested upon him as auditor. And the case against Mr. Fadl is put against him on the basis of fault in Lebanese law, which we say is equivalent to concepts of negligence and willful neglect. And so that, again, is the setting of the scene insofar as the way the allegations are framed against the defendant and also against Mr. Fadl. Mr. Fadl applied to remove himself on the basis that there was no jurisdiction for him to have been joined as a defendant when the claim form was issued, and alongside DTME's unsuccessful application for summary judgment, Mr. Fadl applied for a declaration that the court didn't have jurisdiction to determine the case against him. And this application became the subject of Justice Roger Giles's judgment on the 25th of August 2017. And we have that if we go to the hard copy, it's in the first file under tab 4 at page, under tab 2 at page 4. If we are on the electronic bundle, I understand it's 001382. And so we have under tab 2 of this document, we have on the second page Mr. Justice Giles' order that the court did not have jurisdiction to determine a claim against Mr. Fadl. And then in paragraph 2, that the claim form would be set aside as against Mr. Fadl, but without prejudice to any application that the claimants may make pursuant to Rule 20.7 for an order that the second defendant be added as a party. So this is how we arrive at the position today, because of course what happened is the claimants did just that, made the application under 20.7. And so the position that was argued, and indeed is to be argued in this court, it is as follows: that whilst it's recognised that the court's position was that the appellants should not have joined Mr. Fadl at the outset when the claim form was issued, that the proper procedure to adopt was a 20.7 application in order to maintain the case against Mr. Fadl. And so, in other words, whilst under 27 there may be prospective jurisdiction to join Mr. Fadl to the action, it's recognised that at the time the claims form was issued, there was no present jurisdiction. And that's the way in which the matter has come to be framed. Insofar as the judgment is concerned of Justice Giles, which we have here in this tab, which follows the judge's, the court's order, we have a lengthy discussion about exclusive jurisdiction, which we needn't go into. Various points were taken by Mr. Fadl, and they didn't succeed, and so we needn't trouble the court.
I think you can go and see why Sir Roger Giles was wrong in his judgment.
Yes.
Just proceed on from there onwards, because
yes,
we have read the records, so it's.
He deals with that at his judgment, and I'm at page 18 of the hard copy. It's paragraph 70 of the judgment. Really, what it comes to, we would say, is this: that a case against the appellants, which the judge accepted, was that the appellants couldn't go through any of the gateway provisions. They couldn't make any of them apply at the time when the claim form was issued. And that was why the judge held as he did. And so that is essentially the reason for the court coming to the view as it did at that early stage in that first application. And so it sets the scene for the appellant's application to add Mr. Fadl as a defendant party under 20.7, which I was now going to take the court to. We find the application, I'm in the first file still, at tab 13, page 117, which is 001495 of the electronic bundle, where we have the application that the appellants made claimants to join Mr. Fadl as a new party. And you can see the way it's put. The reasons are very obvious. That it's necessary, the appellants say, for him to be added as a new party so that the court can resolve all matters in dispute in the proceedings.
Desirable rather than necessary.
Yes, I'm so sorry. It's falling back on heritage and I shouldn't. Thank you. Absolutely, the test is desirability. And we say it's desirable because in our respectful submission, if I can describe it this way, again, falling back a little bit on heritage, we would describe any claim that proceeds in this court of this nature without Mr. Fadl as being what we would know as Hamlet without the prince. Mr. Fadl is inextricably bound up in this matter. It's his work, it's his failures, really, our case is that everything that was done comes back to Mr. Fadl's door, and therefore to have a trial, develop this in due course, but to have a trial in this type of case without Mr. Fadl is indeed without the prince. And so we also frame the issue of desirability in other ways as well, which I'll come to in a few moments, but essentially that is what we're saying. So we have here the application to join, and then that's supported. If we stay within this section of the bundle, I can deal with this very swiftly. The schedule to the claimant's application notice appears in a hard bundle, page 119, and so we pick that up. That must be 496, I think, 497 on the electronic bundle system. And so if you're happy to go to paragraph 4, please, we have a summary of the way that the application was put, really in terms that I've just summarised. Mr. Fadl, central to the claimant's claim, due to his role as audit principal, partner in DTME, head of Deloitte and Touche operations, central to all matters. It's right, paragraph 5, the allegations against Mr. Fadl, serious in nature, should be heard and responded to, particularly given Mr. Fadl's prominence in the audit market. And not only is the DIFC the appropriate venue, the claimant's submit is the only venue, and clearly appropriate for the claimant's case to be heard alongside the claim against DTME. And you see coming through in paragraph 5 something that is developed a little later, and it is part of our case on desirability, that we say is an element of this. There is an aspect not simply of having Mr. Fadl in court to deal with the essential aspects of the case, but actually there's also an element, we say, of requiring Mr. Fadl to take responsibility for what has happened here. Because on our case, we have these very serious allegations of money laundering and terrorist financing. We know from the history of the matter that the history of LCB and its involvement in these matters is indeed opaque. And if we are right in what we are saying, it is only not just necessary, proper, but desirable that Mr. Fadl will be here to take responsibility for what has happened. And so the application is also supported, if I can just reference these matters very quickly, by a second witness statement that is submitted in the action by the lead claimant, Mr. Nahl. And we have that under tab 15, page 128, which I think is 001-506. And in this, again, I invite the court to read it at the court's leisure if the court has not already had an opportunity to look at it. But at paragraph 6, you will see assertions that are of course, intrinsic in a case, in an application of this sort, where Mr. Abdul points out, paragraph 6, that if there were to be separate trials, it would be enormous duplication, unnecessary expense, and of course, we will also see added into that, it comes through again later in the papers, the concern about different inconsistent rulings, and there's also articulated in this witness statement a concern about the ability to have a fair trial in a jurisdiction which is not necessarily famed at this particular point in time for its adherence to the rule of law. And so we have all of these matters coalescing in this, and that's then supported, just again so that the court has the right documentation at its fingertips, in tab 17, which is the claimant's skeleton argument in support of its 20.7 application, which the court will have at 001530. So I'm in tab 17 now. And again, I don't want to listen to have a formal ceremonial recitation of it, but just to draw the court's attention to paragraphs 60, running through to paragraph 32, where the appellants articulated again all the matters that we say make the application desirable for Jamal. And so I wasn't proposing to take you through it and summarise it, but again to point this out as being the relevant material for the court, if the court wants to see exactly what was before Justice Giles on this application.
The real issue for this court is the power rather than the desirability of it, as I understand.
Absolutely.
Wait to hear what's said by the respondents, but that's the reality.
Yes. I respectfully agree entirely. This is all scene setting for the court.
Yeah.
And so we then get to the judgment of Justice Roger Giles, where he holds that there's no jurisdiction, and that's in our first trial at tab 3. And that's our electronic page number. Thank you for a moment. 398. We're told that's 001 398. What I was proposing to do was to take the court to the order, the rule, and then come back to this judgment. I just wanted to reference it at this point so that you know exactly where it is. But then, having looked at the order and having looked at the status of the rule, to then come back and say exactly what Mr. Justice Roger Giles did and why we say it was wrong.
You could take it that we're familiar with this, and there are 2 points you have to grapple with. The first is, do the rules constitute a regulation? And secondly, if they do, is it one that's, quote, apt to confer jurisdiction?
Yes.
Those are the points up there, essentially.
We might conceptualise it slightly differently and say that looking at Rule 27, is there any reason why any limitation should be put on that? Because the way the learned justice below dealt with it is that he came back to the gateway principle. And so our first submission would be, well, actually, you don't need to go there, and 20.7 is enough to take you there.
Well, there's an element of circularity that arises in relation to E of Article 5.1a, because that in itself brings in regulations. So to talk of this court having a statutory jurisdiction is perfectly right and proper. We all understand that.
Yes.
But as a matter of construction, you simply then got to look at 5.1ae and say, do we have a regulation that confers jurisdiction?
Yes.
Now, I understand you can approach it in a number of different ways, and the real question for you, and indeed for them as day at the end of the day, is, sorry, forgive the pun, not intended, but it's the question whether or not that rule can have the effect of giving jurisdiction. And if it doesn't, what good does the rule do at all?
Well, indeed. I mean, that is indeed our position, which is why, in fact, and I'm very happy to deal with it that way. But it's
Well, I think Justice Cooke has rounded up for you the issues, and you can just go on from there onwards.
Yes.
So
Take
it's-
it in whatever order you've got planned.
Yes.
You can see that I think we've isolated what the real points
Yes.
are, and those are the points on which, at the end of the day, we would like to hear you both.
Yes. Well, thank you. So then, maybe I can speed up a little bit by going straight to the joinder rule in Rule 20.7, because I'd like to invite the court just to contextualise that slightly as part of our submission. Now, we find this in the law bundle, and it's at the end of the law bundle. We have it as I have it in the hard copy as tab 14. It's the law bundle 329 on the electronic version.
And the hard copy?
In the hard copy, it's tab 14, right at the end. It was added in late. I think you should have it.
There's no tab.
Yeah, it's three.
Page, there's no tab in this bundle that I got. What is your
It
page
should be
number?
324.
Huh?
Should be at 324.
324
It's
is
in the
hard
hard
one, yes.
bundle.
334.
And in the soft electronic version, it's 329.
Yeah, okay. Yes, 20.7. Yeah.
Yes. And so the rule itself at 20.7 appears at page 327, 328. And as his Justice Cooke has pointed out already, it's a desirability test. And it's noted that if the position should change under 20.8, the court has to order a person to cease to be a party that it's not desirable for the position to continue. And so if we go back to page 324, we can contextualise this a little. It's interesting to see, we would say, at the first glance, at Rule 1.6 and at 1.7, that there is an overriding objective that the rules seek to achieve, which is to deal with the case justly and to deal with it fairly. And we would say, as part of our submission, looking at the application of 20.7, that it must go into the equation that the court should consider its construction and application of 20.7 against the background of 1.6 and 1.7. And one would ask from our side of the court, rhetorically, how can you do that without having Mr. Fadl here? And so that's a matter that we mentioned in passing. And of course, yes.
What is bothering me is why do you say 20.7 and the rules themselves confer jurisdiction?
Yes.
Why do you say that? Why do you say they confer jurisdiction?
Let me go straight
Because according to Justice Giles, it's merely procedural and it is a confer. To me,
Yes.
that's important.
Let's go straight to it.
Yes.
It's the status of the rules, essentially.
Yes, status and
What is
status.
the status? And so the rules we can see, we're helped to some extent because we begin at 1.2.
Yes.
The rules are made by the president of the IFC, and we see that at 1.4 there are amendments to the rules, and they're made by the Chief Justice, by Your Honour. Therefore we're already into the standing status of the rules. We need to look to see quite what the empowerment is to approve and issue the rules of court. And so we need, in fact, to stay within the law bundle, and we need to look at the tab 4, which is law number 12 in 2004, the judicial authority.
What's the page number?
So in the hard copy it's 142, in the soft copy 001145.
Yes. Okay.
Thank you. And so, looking at this, we can see from Article 4, if we go to page 143 at the bottom of the page, the duties and powers of the Chief Justice, and 1 and 2 setting out has a Chief Justice and those powers. And then over the page at 144, under section 2, technical duties and powers, we have under A, to propose and submit to the President the draft of the IFC laws concerning any matter falling within the court's jurisdiction, and B, to approve and issue the rules of court and the IFC regulations. And so we have here a clear statement of the Chief Justice in its power to approve and issue the rules of court and the IFC regulations. So the question then arises, well, what is meant by a DIFC regulation and a DIFC law?
Yes.
So if we then go back a bit, go back to page 143, and we're in Article 2, we can see that a DIFC law is defined as any law issued by the ruler in relation to DIFC. And then DIFC regulations talks about any rules, regulations, bylaws, or orders relating to DIFC issued by the President or by a DIFC body. So we can see that the definition of DIFC regulation includes any order or rules, particularly, issued by the President, and we've seen that the rules are issued by the President or by a DIFC body. And so we then need to go on to the next step and say, well, that's fine, but what is a DIFC body? And so we have to move around a little bit. We need to go back to tab 3, and we need to look at law number 9 of 2004, which is, if I can put
Well, before you go there, you've got Article 2 itself, haven't you? At page 142.
Yes.
It refers you to law number 9,
Yes.
and any other body established pursuant to the DIFC laws.
Yes, absolutely. And I'm moving to show you that the DIFC body includes this court. And that's the key point that I'm seeking to get to. And so, if I may label law number 9 of 2004, the financial free zone law, and we have it at tab 3, page 127, and it's 001130. And we can pick this up. It's a little tortuous, but we can pick it up at page 128 in Article 3, where the financial free zone is established in Cambridge and is known as the Dubai International Financial Centre. And then subparagraph 3, the following bodies shall be established in the centre. And so one of those bodies is C, the Dispute Resolution Authority. And we may note in passing, as we turn over Article 4, the role of the centre to be the financial centre of the Emirate, so we have that very broad objective that's been established and is the underpinning of where we're at this morning. And then if we turn over, we need to go to page 135 in the hard copy Bible, Article 8. We see quite clearly that the dispute resolution authority shall be comprised of the centre's courts. And then again we pick up a very wide power in the rest of Article 8, but we particularly note in passing subparagraph 5 that the Chief Justice is the head of the dispute resolution authority responsible for its administration, and then under 5 also we just note the width of the power that the Chief Justice has in F to appoint any natural or legal persons in accordance with the terms and conditions he deems appropriate to assist the dispute resolution authority. And so we say that this establishes quite clearly that the dispute resolution authority is defined to include the centre's courts, and therefore it follows that in fact the rules of court have the status of DIFC regulations, and that they've been properly promulgated by the Chief Justice of the Court, empowered to issue, alongside, of course, the President, who is also involved in this function. And so we would say, therefore, that the rules of court do have the status of DIFC regulations. And that's why we say that order, the rule 20.7 is a rule, when we then come back to it, that actually is a freestanding rule. And so we say that it does give the court significant discretion to add a party in an appropriate case.
No, my question is, why do you say that the rules of court confers jurisdiction on the court rather than merely regulates the operation and procedure of the
So
court?
our first position on that is to say to you that there's absolutely nothing in 20.7
Yes.
that suggests that there's a limitation to jurisdiction. There's nothing there that says you have to go through a gateway. I'm going to come to gateways in a second. But there's nothing there that says you have to go through it. And therefore, for that reason and that reason alone, if the court requires a party to be in attendance, it's because it's desirable for that to be the case in order to resolve the matter. The court has power to do that under 20.7. That's an unexceptional provision really internationally in courts. And so we say that there is no fetter other than the requirements of discretion and forum issues that would restrict.
Well, what if I say to add in a party under the provision you're referring to just now, means the party itself must be already within the jurisdiction. You cannot create or confer that person jurisdiction right to come into the IFC by adding him as a party. He must be within the jurisdiction before you can add him as a party.
Well,
what do you have to say to that?
Well, it's certainly right in terms of the initial position, hence the issue with the claims form.
Yes.
Once you've got an action, this is our secondary position.
Yes.
Once
Now he's coming in as a third party. He's going to be added as a party.
And then if there isn't a need to find jurisdiction over and above 20.7, we can find it in E, in 5AE. And so I was going to take you to those jurisdiction gateways and look at E.
Okay.
We have two places to look. And the first is in tab 2 of the law article,
Page
99. and I'm referencing here the court law, number 10 of 2004. And, I'm so sorry, that's 001101. And in particular, I'm taking you to
But my bundle 99 is completely. Are you referring to the IFC 10 of 2004? You are referring to the case.
Yes, I am.
You are referring to
I'm taking you to Article 19 in this document,
Article 19,
page 108.
108. Yes.
And so this document set out the jurisdiction of the court.
Yes.
And you're intimately familiar with it.
Yes.
So we're in 1 and we're in 8D.
Yes.
And of course, the significant point is that E is not there.
Yeah.
And so it would be wrong of me just to go straight to law number 12 in tab 4 without pointing out this to you. Because it's the law's been subject to amendment. And we really need to look at law number 12 of 2004, which was amended in 2011. It's under tab 4 of page 142.
What about 19.1D in any event? Is that restricted by the word application?
Well, it is interesting. We've looked and thought hard about that. And we can certainly see the argument that can be developed that 20.7 is indeed an application. And that it's an application over which the court has jurisdiction. And the court will have that jurisdiction in accordance with the laws and regulations, because the court's already established that there is a defendant in respect of which, and a claim in respect of which the court has jurisdiction. So we see that. Our position is that our position is strengthened, and we can go beyond reliance on 19D by relying on the amendment in 2011, which was put in to the law number 12 of 2004, known as the Judicial Authority. And here we're now looking at Article 5 at page 144. And so this is 001146. And this article was reshaped in October 2011. You can see through a very small italicized reference to the date. And you note over the page at page 145 at the very top that the jurisdiction is effectively enlarged by the revised Article 5 and to include any claim or action over which the courts have jurisdiction in accordance with the IFC laws and regulations. And so we would say that this is such a case because there is up and running in this case a claim against the defendant, DTNE, which is up and running, and it's a claim over which the courts have jurisdiction. And the courts have
that's the whole thing. There's Justice, there is secretary.
Well, it is.
Going round and round.
It is.
Because E speaks about any claim action over which the courts have jurisdiction. So the courts must have jurisdiction first.
Yes.
Then E applies.
Well, the courts have jurisdiction.
But you are using E to go to the rules and come back to E.
Yes.
But it says here E, courts must have jurisdiction first.
Yes.
So how do you show that
We're
in
using
your particular case, the courts have jurisdiction over Fadl, Mr. Fadl.
Well, the
Or
court...
Mr. Fadl can come
Well,
to...
Yes, and we say the court plainly has jurisdiction over the claim in this matter, claim against DTME. Insofar as the court's having jurisdiction over Mr. Fadl is concerned, we say that the courts do have that jurisdiction because 20.7 allows the court, once there is a claim up and running, the court has the jurisdiction to be able to add Mr. Fadl at that point in time. So the point being that this is where we quibble from the learned judge below, because the learned judge below is saying, that if you couldn't go through a gate, effectively saying, look, if you couldn't go through a gate at the beginning, not going to go through it now. And we're saying, well, hold on, that's not actually right, because what's happened is that we've now got a situation where we have an action that's up and running, and we can now go through a gateway, because on our construction of E, that is sufficiently wide to enable us to do so. But in any event, we say, we don't actually need to, because 20.7 has the status of a DIFC regulation. And therefore, there is, insofar as the jurisdiction of the court is concerned, the basis on which the court is acting, the court is acting under its power in 27, which is to bring another party in where it considers it desirable to do so. And so that's how we would deal with that. And we would say that it can't be right for the court not to have that power. We would say that there's almost a common sense position that takes you to that it would be really seriously inconsistent, if not incoherent, for the court not to be able to do that. And one could posit all sorts of other issues. I mean, are we in a situation, again, I was going to come to it later, but it's part of our submission, are we, one of us rhetorically, in a situation where, for example, DTME wanted to bring in Mr. Fadl because they wanted, let's say, a contribution or something of that sort, and they wanted him added as a defendant. Are we saying, one asks rhetorically, they can do that because there's jurisdiction for them, because they're a DIFC body, but there's no jurisdiction for us as a claimant, even though the action is up and running. And we would say that is, with the greatest respect to the court, a thoroughly inconsistent, if not incoherent position for the court to find itself in. That can't be right. So, when one then comes back...
Wouldn't that be also opening the floodgates? So anybody can come in and file in, the IFC.
Well, let me answer it in this way. I mean, in one sense, the way in which the jurisdiction is configured, you've always got that in one sense, because any DIFC establishment is already in that position.
It's intended to do that. It was meant to do that.
Well,
that's what you're saying.
It doesn't open the floodgates, does it, for this reason? You start with a claim which plainly falls within 5A, regardless. And this is a tack-on to it. So it doesn't open the floodgates.
Exactly.
And you've got a desirability question which brings in the whole business of foreign convenience, balance of convenience. Is it more sensible to have it in one place here? Is it more sensible to have it in one place elsewhere? Is it more sensible to have it in 2 or 3 different jurisdictions if you've got multiple parties? But that's all part of the court's discretion, isn't it?
Yes.
But it only arises once you've got an original jurisdiction against some party.
Yes.
Now, you pointed to the illogicality which arises, and it is an oddity of this court's jurisdiction that the claimant's own location is a sufficient feature to give rise to jurisdiction, and that's unusual in the world generally, but nonetheless that's the position. But there's a more fundamental question, it seems to me, which is, what does this rule do if it doesn't give you jurisdiction? Is it really all it's saying is that the court has a procedural power to stick a couple of defendants in the same action when there is already jurisdiction over them by one means or other of the other gateways?
Yes.
In reality, that adds nothing at all. It would give you a discretionary power to do that which there is a right to do.
Yes.
In any event,
yes, and absolutely, I was going to move on to that and indicate those as being our position. Somewhere in the documents, I know we've made this point, but if Mr. Fadl and his legal team are correct in the way they're presenting the matter, it would render 20.7, but also E, effectively OTOs. What are they doing there? And if one looks
well, not E necessarily, because there are lots of other regulations that might, in theory, give rise to jurisdiction.
yes.
It does make 20.7 a very limited impact indeed.
Well, indeed, which is why we're presenting this application to you, the appeal to you, and saying that actually look at 20.7. We actually, on the face of 20.7, we don't even need to go to 5A. But if we do, that's where that is where the jurisdiction is. And so perhaps now we should look at the judgment, which we've already referenced in 5.1.
Is it possible for you to develop your argument without referring to the judgment? Is it possible for you to do that?
Yes.
Without referring back to the judgment?
Yes, with pleasure.
Because we are not bound that we can look at the problem in a different angle altogether without, referencing to the judgment. I don't know.
Yes.
I leave it to you. I leave it to you to do whatever you feel comfortable.
I can do that with pleasure. The heart of the judgment, which we've already indicated where it's wrong, is that it's taking the view that if there was no jurisdiction to begin with, there's no jurisdiction now, and for the reasons we've articulated, we say that's not right, and therefore the point that's made on that is that, well, if you're right, we're right, there's an enlargement of jurisdiction. And
you have already said that the rules to add the party was derived from the 19 and all those things.
Yes.
And you have argued that that confers jurisdiction,
yes,
and by virtue of that, Mr. Fadl was probably added as party to the courts.
yes,
I mean, that's your,
that is
basically your argument,
yes,
isn't it?
it is.
So, is there any authorities that you can cite to support your contention?
There is extraordinarily little on this.
Yes, indeed.
I can take you to.
That's one case.
Well,
What was the name of the case?
there's Karafi and Koran.
Korafi.
And I was going to take you to those two. We can do that now.
I don't know. This is.
Whatever you want to do.
We leave it to you. We don't feel that you are constrained by my comments.
No, but by the same token, obviously as an advocate, the last thing I want to do is trot through material that the court is already very familiar with. So I'm very happy, if it's convenient to the court.
Me too. I leave it to you. Don't feel, as I said,
Thank you.
restricted or constrained.
Well, I don't think anybody is saying there's any authority that directly assists us on this point at all. But all you get is background hints on this.
Yes, that is right. And we can look at that because it's the best we can do in terms of trying to determine that. Perhaps I can deal with it in this way. If I can deal with Justice Giles's judgment before reading it in this way. We also would respectfully say that in a sense, the learned justice's reference to the regulatory law in his judgment really doesn't serve his case terribly well, as it were, in support of the judgment. because rather like 20.7, there's a discretion built in. And so it's not a floodgate situation for that reason. And if we look at it, there's no express reference in 94.2 to any jurisdiction being conferred. And so just before we leave there, to make the point that again, if one looks at the judgment, the learned judge did misdirect himself with reference to this line of argument, and the reference to the Article 94, the regulatory, doesn't take us any further at all.
But there are other provisions of the regulatory law that give you other jurisdictional help.
Yes, yes. We
So
see
that,
we see that.
although the judge is not, doesn't go into any detail,
Yes.
it looks as though from what he says he had in mind the
Yes.
context of regulatory law which applies within the DIFC,
Yes.
and
Yeah.
has certain requirements obviously for licensing and so on
Yes.
within the DIFC. So it's hard to see how in fact you get any assistance
Yes.
one way or the
One
other.
way or the
from
other, precisely.
regulation.
And that's my very point. It's a matter of calibration and where that line is drawn. And so far as 20.7 is concerned, the calibration is a desirability test subject to foray. And those arguments. Yes. Just bear with me a moment whilst I go to the correct reference here. So, may I take the court's pleas to tab 6 of the Law Bible, which is page 170, 001 172.
What was the page again? Sorry, I beg.
It's page 170.
170. Sorry, I beg. Yes.
And so, it's a lengthy judgment of this court, and we can pick up the. First of all, we need to pick up this, that the case covered the period between the former law being applicable and the new law being applicable, which you pick up at paragraphs 2 and 3, where the new law was promulgated. And the court approached the matter on the basis that it really should be applying the revised law, and that's in paragraph 4. The facts of the case, we pick up at paragraph 7, where a bank, the Kuwaiti bank, agreed to advance dollar funds to the claimants to enable them to make investments outside Dubai. And the investments consisted of capital guarantee investment products. And the bank recommended claimants should take advice as to suitable products from two individuals, from Mr. Kerry, from Mr. Kerry, Saracen Dubai, which was described as a branch of Saracen Switzerland. And so we have actions taking place both with the Saracen Dubai and in Switzerland. At paragraph 9, you can see at the beginning of that paragraph that the claimant signed and returned to Saracen Dubai a number of documents, including the current custody account forms. We can also see, if we go to paragraph 10, that the third claimant had opened a current custody account for Saracen Switzerland. And so we have the scene set, as it were, for an issue over jurisdiction. And the claims are summarised against Saracen Switzerland at page 176. And it's noted, just again contextually, paragraph 24, page 177, that it was common ground that the relationship between Saracen Switzerland and all the claimants are governed by Swiss law. And we have then at 25 a very, very short summary of the allegations in particulars of claim that Saracen Switzerland intentionally or negligently failed to give sufficient advice to claimants. We then get to, we get closer to the jurisdiction claim. Paragraph 26 at page 178, it's pleaded that the claimants acted as agents for Saracen Switzerland, and as such, under Article 32 of the Swiss Code, their acts and omissions are imputed to Saracen Switzerland, and so vicarious liability arising. And then the next subheading above paragraph 29, the claimant's submissions to jurisdiction. The material, the contractual documents between the claimants and Saracen and Dubai was signed in QA and sent back to Saracen and Dubai. These contracts were therefore wholly or partly formed within the DIFC. And so we'll see as we go on through this that in fact there wasn't a problem establishing jurisdiction here, which is why the case actually at the end of the day doesn't really assist us, because Rule 20.7 was not an issue, and the jurisdiction was established in this case under Gateway A. But we can pick up, again, if we go to page 187, the judgment then embraces a discussion about the relationship between the claimants and Saracen Switzerland. Which again, we needn't read it over because we pick up a reference at paragraph 62 to 5A1C, which is the provision under which jurisdiction was established, and that there was a civil or commercial claim relating to the IFC. And it's really at the very end of this. So we have established, and you will see that as the judgment proceeds, paragraph 72, 76, particularly paragraph 75, the court concludes that jurisdiction is established through Article 5A1C. And it's only over the page of 194 that we get any discussion of what might be closer to our situation, the claimant's alternative case, which was under A1A. And that's described as entirely misconceived. And this is the best, as it were, the strongest that can be set against us, which is an our argument. Paragraph 82, Saracen Switzerland is not a DIFC body, DIFC establishment or licensed establishment, nor is it a party to any claim against Saracen Dubai, which is a DIFC establishment or licensed establishment. It's necessary for the purposes of this provision to show that there is a claim for a remedy by or against the party which falls within one of four identified categories. It's insufficient to rely on the fact that a different party to that against which the claim in question is brought happens to be a party to the proceedings. And so we say, well, very, very interesting. If jurisdiction had not been established under C, then we see how this case could become closer to ours. It would raise a very similar issue. We see that because at that point there would have been an application under 20.7 to join. And then the same issue would have arisen. But it didn't arise in this case. And so, in that sense, it's right to say that this paragraph really doesn't take us any further. There's no 20.7 application. Also, the court actually, although it was looking at the new law, the fact is that this all did arise under the old law before he was there. And so For those reasons, we say interesting, but actually it really is not going to help the court at all in determining this matter. That's why this case is an important case for the court. There is an important general principle. It's the first time it's come before the court, and the court needs to grapple with it. And there's really nothing in the previous jurisprudence that actually is going to inform the court as to how to deal with this.
Well, one of the surprising feature of that decision on the face of it was the court's decision to ignore the exclusive jurisdiction clause.
Well, yes.
Which, it might be said, exemplifies a long arm approach, a jurisdiction grabbing approach.
Well, whether there is or there isn't, we can have lots of discussions about various international courts that do ordain to indulge in jurisdictional grabbing. But
the nature of the provision you rely on is
yes.
one which is commonly found in one way or another, whether it's expressed as necessary of a party, necessary or party, or whatever. In most common law jurisdictions, I think I would be right in saying it appears in one way or another.
Exactly. And we've set all that out in the material that we put in front of Mr. Justice Giles.
He's right in saying it doesn't really help, does it? Because you have to look at the position here. All you can say is that it's something that is, as a general matter, of some international recognition.
Yes.
That's all. It's not so out of the way as to think that things are stored.
We can certainly take comfort from it, and we can certainly urge this court to say that this court should not put itself in a special position and should not, it should be informed by what's going on by jurisdictions that are exercising their jurisdiction in international cases. And so we say that it is helpful, but we certainly don't for one moment say it's determinative, and that must be right. And that's why, as part of our submissions this morning to you, I wasn't proposing to take you through it, proposing to reference it, as we have done, but not to actually get through it, because it's not determinative. But it is helpful. It gives you a steer as to how the court should be dealing with things. I mean, one of the examples, for instance, that we give in one of our submissions, one of our statement arguments, is to say, well, just suppose that you had somebody in Mr. Fadl's position, a party, who, as part of a fraud, was holding money. Are we really going to put the case rhetorically? Are we really to posit that this court couldn't deal with that? That's not what this court, we would say in our submission, is established to do. It actually is going to really artificially limit the jurisdiction of the court. And so, in discussing the matter with Your Honour, I would say to you, well, actually, it's not so much an expanded jurisdiction, but it's actually preventing the court being hobbled in its jurisdiction. Because if my learned friends are right, they're hobbling the court. And that can't be what the court is supposed to be doing, which is why we then go to the more general approach internationally and say the court takes comfort from that.
That's really just a question of policy.
Yes.
And obviously, policy as a driver when it comes to look at interpreting rules. But
there's a policy here, isn't there? Because if we look at the rules of court, the overriding purpose is to deal with the case justly and fairly. And when again, we ask rhetorically, how do you do that? You can't even get all the parties before the court. You actually can't discharge a basic function as a court. So it's a bit more than policy.
Well, again, the point only takes you so far, doesn't it? Because it can't be said that the case can't be decided against DTME without Mr. El Fadl as a party. He's obviously a critical element of the equation, and his evidence might be required and so on and so forth. But the case could be decided without that party being present. But the question of justice and convenience is that if he's going to be sued anywhere, where is the logical and sensible place for him to be sued?
Precisely. And of course I can't go that far and say you can't deal with it. Of course I can't. We've never said that. Absolutely. But I mean, it's not simply a question of the matters, the factors that Your Honour's just posited. It's a little bit more than that, because it also arises in the context of the possibility of inconsistent judgments.
Yes, yes.
So we have that concern as well. And then there's the issue of cost as well, which also comes into it. So it's multifaceted.
This is the desirable aspect of the...
Yes. But it's very important. And it is the driving way for 20.7. That's why it's needed. Is it of any help? I was going to take you to comment. It's the only other case that it seems to us.
I think
any sort of
we're quite familiar with Corinne.
Sorry?
I think we're quite familiar with Corinne.
You think?
We are quite familiar with Corinne.
What assistance do you get from Collins, really?
Well, the truth is, it's really paragraph 84, so I can go straight to
Paragraph
if
84.
that's the one here.
Page.
So we're in tab 7,
Page.
the judgment division 201, and the page in the hard copy bundle, paragraph 84, is at page 216, which is at 001218.
Yes.
Thank you. Would you talk to me just one moment, please? Thank you, and grateful support. So, paragraph 84, in my view, the answer to the question is no. Access to the jurisdiction of the court through the gateway provided by paragraph A of 5A1 of the original law was amended by law 16/2011. It's not so restricted. Whatever may have been the position before the issue 2016-2011, and I should not be taken to indicate that the disagreement would be expressed by the Chief Justice of his judgment on this field. The position following the issue of that law seems to be free from doubt. Access through the gateway provided by paragraph A of 518 is available in the case of civil commercial claims and actions to which, in essence, the LAFC establishes a party. Let me get to this bit. Once it is shown that the party by or against whom the civil or commercial claim is brought is an entity or enterprise licensed, registered or authorised by the DFCA to provide financial services or to conduct any other activities in accordance with the LAFC laws, the requirement under paragraph A is met. The jurisdiction exists ad hominem. There is no further transaction-based requirement comparable to those imposed under paragraphs B and C. We would say that actually does help us. Again, it's not a clincher by any stretch. We don't suggest we advance that to the court. But we do say it's again helpful. It gives a steer, and it certainly makes the point where we look at once it is shown that a party by or against whom, certainly makes our point for us in terms of DTMA wanting to join Mr. Fadl if we wanted to. But we can't. So it certainly makes that incoherent, inconsistent point. But it does give a bit of a steer, we would say, for saying that once something's up and running, then it's a perfectly proper conclusion for this court to come to say that Rule 20.7 is available and can be utilised and deployed in a situation just as we are in, subject to desirability and subject to forum. And so, essentially, those are our submissions. I'm in the court's hands, but I wasn't proposing to say very much more. It's obvious to us that the court has the points, and they never get stronger by repetition. We say they're pretty strong as they are. It can't be right for us not to be able, the court, not to be able to have Mr. Fadl here. It cannot be right for the court to be hobbled in that way. And that is essentially our submission.
Thank you.
You haven't addressed us at all on Rule 21.
Well,
and the same issue may or may not arise in that context, but the tone of the rule is rather different. I don't necessarily want to distract you by sending you to that. But I just need to know whether, in fact, you do make any argument that hurts you in relation to this by reference to that one. Again, don't let me take you out of it. If you're not planning to raise any arguments in relation to it, that's fine. We'll get the matter as it stands.
I wasn't proposing to.
It's just the same policy.
Yes, so it's exactly
Mainly
the issue
arises
arises.
but the wording is different, and if one's looking then at the absence of conferred jurisdiction,
Yes.
there might potentially be a difference between the two, which would plainly be undesirable as a matter of policy.
Yes. Yes. Although I'm just looking, for it because it's not in our bundle.
Right.
And so we need a minute or two to just reflect.
But you'll recall it's where the defendant seeks a contribution or an indemnity, so that in the present case there might be no problem because the defendant himself qualifies as a gateway because of its residence as a licensed body in the DIFC, so would get into the gateways anyway.
Yes.
But if there was a different head of jurisdiction established, because, say, the claimant was such a body, the defendant only came in on that basis, and then the defendant wanted to join
Yes.
under RDC 21,
Yes.
slightly different issues would arise, but the same principle.
But it's exactly the same principle, and that is again the point that I was seeking a way to take out of Conor, that the court must have power to be able to bring all the parties together, and the injustice would be even greater if a defendant wanted to be able to bring somebody in as a third party for a contribution, but couldn't do so. Again, that can't be right.
Miss, have you finished that, Mr. Fisher?
Well, I think so. Yes. Yes. I mean,
Anyway, I just want to ask Miss Analyst, Miss Day, how long are you going to take in your submission?
Well, it depends how many questions you have. I hope the points are quite short.
Yeah, I was
I-
thinking we can take a 10-minute break.
Yes, of course,
And
yes,
then,
yes. We'll
you know,
comfortably
in the
finish by
meantime,
lunchtime,
Mr.
yeah.
Fisher can look at 21 in case you want to add it up later when we come back. So we'll take a 10-15 minutes break now.
thank you.
Thank you very much.
All rise.
Do you have anything to add, Mr. Fisher?
Thank you. Well, I'm grateful for the opportunity to look at 21. It seems to us, with respect, that the decision in this case is in effect going to drive the position after 21 as well. And if one looks at 21, the ability of the court to permit the defendant to raise a counterclaim would indeed be limited if the respondents are right in the way they approach this, particularly so that we've got a non-DIFC party really to be contemplated that they couldn't bring a counterclaim. And again, we would say that cannot be right. So we would conclude our submissions by saying that actually, look at 21, that also assists us. It's exactly the same issue. And we're very good to the court for drawing it to our attention.
Okay, thank you. Yes.
My Lords, we base our submissions on JAL itself. We say that's the start and the end point. And we say this court can't act on the basis of what is said to be right. One has to look at the jurisdiction that was given to this court as set out in Article 5. And perhaps if we start with that
Where can you find that?
it's 001144, or in the hard copy, it's in the Authorities Bundle, tab 4, page 142. And the jurisdiction of the court is very clearly set out in Article 5. And there has already been a ruling by this court that there is no jurisdiction under any of these gateways against Mr. Fadl. And just so that the court's clear, what was considered by Justice Giles in relation to the gateways was not only 5(1)(a), 1A, but also E. So E was expressly considered because there was a claim.
But in a different context.
Well, the way in which it arose was this. I think it was said by Mr. Fisher that Justice Giles had determined that this was the correct procedure. If you look at the first decision, what happened was there was a reference to Mr. Fadl being a necessary and proper party in the skeleton argument only.
Yes. And he said the matter turned out rather differently when unpacked, because we're looking at the position raised already at defendants.
That
had to be justified.
That's correct.
And 5(1)(e) was used by taking two other statutes suggesting there was a basis for jurisdiction which he rejected and from which there's no appeal.
Yes, correct. And so I accept that this specific issue, can you use 20.7 to create jurisdiction, isn't considered. But strictly speaking, it is important to remember that the claimants did try and say that Mr. Fadl fell within, for example, the regulatory law and the law of obligations, and that has been rejected. So they have already had a couple of bites at the cherry, so to speak, and those are the circumstances in which they come before you. And we do say that's important to remember, because when one talks about what's just or fair, it may be in another case that somebody is able to bring themselves within the regulatory law and therefore within the gateways. But the fact is there is a finding that Mr. Fadl doesn't fall within any of these gateways that has not been appealed. Then if you look at JAL itself, we see there the reference in E to DIFC laws and DIFC regulations. That's on page 147. 001147. And I would ask you to look at those words, DIFC laws and DIFC regulations. And then if we go back, please, to 001145, page 143 in the hard copy, you will see that JAL itself draws a distinction in the definitions section between DIFC laws, DIFC regulations, and the rules of court. So the rules of the courts are not DIFC regulations. They actually have a different definition, and they are said to be the rules regulating litigation procedure before the courts. And then if we look over onto the next page, which sets out the powers and duties of the Chief Justice, 001146, under technical duties and powers, 2(b), the Chief Justice has the power to approve and issue, and again we see a distinction between the rules of the courts and DIFC regulations. So again, that distinction is carried through. And then the words that then follow after that are falling within the court's jurisdiction. Now, that passage wasn't read out by Mr. Fisher when he took you to this, and we say that that is very, very important because within JAL itself, it's set out that the rules must fall within the court's jurisdiction. There is nothing that Mr. Fisher can point to you within this that shows that the rules themselves create jurisdiction outside of Article 5. And that, we say, is the start and end of this case. So in order for this court to have jurisdiction...
How would that work for the expression of DIFC regulation in the same subparagraph?
Well, again, the DIFC regulations may fall within one of the gateways. So if you look down at Article 5A1E, then if the DIFC regulations themselves create jurisdiction, but what's interesting is you don't have within Article 5 any reference to the rules of court.
No, I follow that point, but I'm not sure how the words falling within the court's jurisdiction in 4.2b help you when one looks at that expression as qualifying the DIFC regulations as well as the rules of court.
Well, in my submission, it qualifies it to the extent that you must still fall within the gateway. That's what it makes clear, is that you can't have a regulation that's going to create, it must fall within the gateway, i.e. it must come within Article 5AE.
Well, in that case, nothing is added at all by 5AE, is it?
Well, it simply reinforces that you can't create jurisdiction outside of Article 5. So if let's take an example in this case. The court's decided that the regulatory law doesn't apply to Mr. Fadl, so there's no jurisdiction under 5.1AE. He couldn't then create it by saying, well, the Chief Justice has approved something that doesn't fall within 1AE, within 5AE, but therefore that's creating jurisdiction. So we say it is an important qualification. If you remove it, then you're not giving any effect to those words. Those words in my submission simply reiterate that the approval and issue of those rules and those regulations must fall within the court's jurisdiction.
So it must fall into the court's jurisdiction first, then the rule will apply. Is that what you're saying?
Yes. And I do say it's very significant that you don't find a reference to the rules of court in Article 5.
Well, I understand that point, but I'm simply questioning about the words falling within the court's jurisdiction, which appear in 4.2A, B and C, and are therefore very general in nature.
They are general, but they have to mean something, and therefore what we say they mean is that they reinforce that you can only approve rules, laws or regulations which fall within the court's jurisdiction. So they're reinforcing the importance of the jurisdictional provision. And that was something that was noted by Mr. Justice Giles in his judgment. This is a court of limited jurisdiction, and the 20.7 rule has obviously been transposed from the CPR, which has different provisions, obviously in relation to jurisdiction. And as he set out in his judgment, you can have a wider jurisdiction in effect in England. So one still has to, that doesn't mean one can ignore the mere adoption of those rules, doesn't mean that then you can ignore the limited jurisdiction that is given in this court under Article 5. And that is a jurisdiction that's founded on claims and actions. That was the decision that was made. It's those claims and actions that open the gateway.
Yes, well, it was wrong about it, wasn't it? Because it's not simply claims and actions. As we've just seen in Corinth, you look at the identity of the claimant or defendant as well as the nature of the claim. It's too simplistic to say it's simply the nature of the claim, the transaction that determines the jurisdictional question. So in one sense, that's slightly neutral, isn't it?
Well, I think it's still true to say that, unlike in England, you have Article 5, which prescribes the jurisdiction, whereas, of course, in England, you can found jurisdiction on, for example, presence within the jurisdiction and service within the jurisdiction. So there are different rules that apply. And in my submission, that was all he was trying to express, was that one has to be careful about trying to transpose one system to another. Simply because the rule is copied across doesn't mean that the same jurisdictional rules apply. Just dealing with Corinth in our submission isn't relevant to this appeal because it deals with 5(1)A, which is obviously where you have a DIFC establishment. Again, it's obviously as a matter of policy being decided that where that's the position, that founds jurisdiction. And that's clear from Article 5 itself. Whereas, of course, the claimants don't have that in this case. And that's why we come back time and time again to the anchor of Article 5. And what no one has done is within Article 5 to say that the rules of court in themselves can create an additional jurisdiction.
But that's back to the question as to whether it qualifies as a DIFC regulation. We understand your point about the distinction drawn between the two. But if, in fact, it does qualify as a DIFC regulation, is there then capable, is it not, of falling within 5(1)A)(e)?
Well, no, we don't accept that is correct. I mean, as I say, our primary position is you can't take that from the wording of JAL itself, because JAL itself distinguishes between the rules of court and the DIFC regulations.
It doesn't say that they're exclusive. I mean, I take your point that it does draw the distinction and the distinction is carried through. But on the face of it, if by reference to other definitions of the regulation, the rules of court can constitute a regulation, then there's no reason why they shouldn't be given that meaning. It's not done by secondary legislation in an English context. The rules of court have the power to create jurisdiction because the rules of court are made by a statutory instrument. But so it is here. There's delegated powers given first to the President, and then to the Court, and then to the Chief Justice. So there's no bar in principle. The question is whether it does achieve that.
Well, in my submission, it's telling that in Article 5 you don't have a reference to the rules of court.
No.
And if I could understand the point you were making to me perhaps better if within 2B on 001146 there wasn't this distinguishing between the rules of court and the DIFC regulations. But within the law itself, and this is in the paragraph immediately preceding Article 5, there is a distinction drawn between DIFC regulation and rules of court. And that's important. So we do say these definitions were intended to have the meanings ascribed to them. And DIFC regulations, indeed the definition of that, likewise does not include rules of the courts, which is in itself a defined term. So in my submission, one has to apply the law, has to apply it in terms of what it actually says, because somebody went to the trouble of creating a definition of rules of the courts, and rules of the courts is not within DIFC regulations. So we do say that these definitions are definitive within this. So we say the rules of the courts do not fall within 5(a)(e) as a matter of principle. Secondly, we say that there is also this point that is in the judgment as to who the rules are made by. So you will recall that they're in effect made by the Chief Justice. He recommends it to the President, but again, that doesn't fit within the scheme that's set out within these provisions, which are the basis for the court's jurisdiction. And we see that he dealt with that in his judgment. At 103, which is 01424.
Yes. And what do you say about paragraph 104?
Well, we in one sense we agree with that, and so that is a fallback argument, because what we say is when you look at Article 5, the rules can only operate within the jurisdictional limits of JAL, and Article 5 does not contain any reference to the rules. Article 4 says that the rules of court have to be made so that they fall within the court's jurisdiction. So there is nothing that the appellants can hold on to say that JAL gives you jurisdiction and gives the rules. The rules create an additional jurisdiction.
And what do you say the rule does? 20.7. What use is it?
Well, it makes clear that you can, the circumstances in which somebody can be added into existing proceedings.
But if you're right, that person could have been added in as of right at the outset as a defendant without having to join them later. And there can't be any doubt that the court would have power to join them later because there was an existing case.
Yes.
So the rule achieves nothing at all, does it?
Well, it will depend on the specific facts, but the point is this. This court is still constrained by JAL and by the jurisdiction. It has copied across something that came from England, that in England may create additional jurisdiction. So the answer to your question is, if that difficulty arises, the answer is that JAL, the law, will have to be changed. Right. But you can't, this court cannot seek to change it as a matter of policy, even if it's felt, I don't want to use the word desirable, but if it's felt that that would be the right thing to do. The correct approach is to change the law to make clear that this is an additional jurisdictional basis by adding something into Article 5.
That's an entirely logical position to adopt if I may say so.
Yes.
But the effect of it is you have to accept that 27 does not achieve anything at all in real terms.
Well, again, I'm...
Not unless the law is changed in order to create an extra jurisdiction.
Yes, I mean, I suppose...
That's the logic of your position, I think, isn't it? And I understand it.
Yes, I think it probably is. I'm only slightly hesitating because you might have a situation where somebody could have been joined at the beginning, they weren't, and then there are arguments about whether they should be joined later on.
Yes, because it's too late or whatever.
Correct. And then in those circumstances, the rule may have some application. Because someone who is trying to join late could say, yes, I could have joined earlier, but look, it's desirable and in accordance with the overriding objective for me to join at this stage because that will enable all these issues to be determined. So I don't think it's quite correct to say it has no application at all. There may be circumstances in which it assists the court in terms of its case management. So that is an example of when it might possibly apply.
It has a limited ambit in that context.
Yes. Yes.
And the same thing you would say if we get across to RDC 21.
Yes.
The same point arises, does it?
Yes. And again, when you look at, for example, if you have a DIFC institution who can then bring an additional claim. But that is the policy that was set out in JAL when it was enacted. It was decided that the court would have jurisdiction over those claims, and indeed that as a claimant, that would in itself create jurisdiction.
Yeah.
So that is the policy of JAL, and if it's felt that that policy doesn't sufficiently cover things, then that may be something for the lawmakers to look at. But we say there's no proper basis for this court saying that Rule 20.7 in itself creates an additional jurisdictional gateway, which is what we would be doing. There's nothing within the rules themselves to say that that is the case. And I think Mr. Fisher says, well, there's nothing that says it's not the case. But in my submission, the burden is on him to show you something within the rules that would show that they were creating additional jurisdiction. The problem is he can't, because you come back to Article 5 and JAL itself. So those are, in essence, those are our submissions. Just a couple of points to draw your attention to.
Before you go to the next one,
Yeah.
the claimants are saying is that there's JAL. JAL provides for para E, and then pursuant to E, the rules of the court were prescribed. And then the claimant is coming in through the 20.7 to become a party in order to enjoy that jurisdiction. Whereas your argument is the other way around. You must, you must have jurisdiction first, then only can you be added as a party.
That's correct.
That's the way you see, is it?
That's correct. And if it's felt that the rules should include, there should be power to join someone over whom there's no jurisdiction. Let's be very clear, in this case, there's been a specific finding, there is no jurisdiction over Mr. El Fadi.
It starts off no jurisdiction.
Yes.
You add the party in, he enjoys the jurisdiction by being added as a party.
Yes, but we say that would require amendment to JAL.
As it stands, they don't have that.
Yes.
Okay.
Yes. And we say that that's very, very clear from the face of JAL itself, from Article 5, and from the rest of JAL. The rules of the courts are defined within JAL. They're a defined term, and they do not find their way into 5AE.
If you read E, any claim or action over which courts have jurisdiction.
Yes.
You start off with courts must have jurisdiction first.
Correct. Correct.
Then, but if the courts don't have jurisdiction in the first place, he cannot come in and seek for jurisdiction.
Correct. That's the point. And there's nothing within the rule. So my first point on that is the rules of the court are not within that section at all. My alternative point is, even if they are, the DIFC, they come within the DIFC regulations. When you go to the rules themselves, there's nothing within the rules themselves that say they are giving an additional jurisdiction.
Yeah, but there is the IFC laws.
Yes.
Regulation.
But I think Mr. Fisher's argument is that 20.7 comes within the DIFC regulations. But then when you go, one, we say that's wrong. We say it's the rules of the court. But secondly, we say, even if he's right, when you go to 20.7, 20.7 says nothing about giving jurisdiction. Whereas when you look at some of the DIFC laws or the regulations, for example, the ones that Mr. Justice Giles considered as part of his original judgment, those may in turn give additional jurisdiction. But of course, the rules of court don't. And it's not correct to say that we have to find something saying there's no jurisdiction. The burden would be on him to show provision to say, and this is additional jurisdiction.
Yes, you were going on to your other points.
I think these can be dealt with quite shortly because I think we're both agreed there's nothing at all that touches on this specific. This is the first time this has been argued before this court. There were just a couple of things to draw your attention to that we do rely on in terms of the importance of Article 5, which the courts and indeed the former Chief Justice Michael Huang have said time and time again is the start and end point in terms of the court's jurisdiction. If I can take you firstly to an talk that was given, it's a long time ago in 2008. It's in 01942 of the electronic bundle, tab 23, page 561.
And in your hard copy?
It's 561.
561.
File 2.
561.
And the particular passage that we rely on is at 563 of the hard copy, which will be 001944.
Common law island in the civil law ocean. Yes.
And you'll see halfway down there's in bold the heading jurisdiction, and then he sets out Article 5, and then he also refers to Article 23, and then 3 paragraphs at the bottom he says Article 5 serves the purpose of both circumscribing subject matter jurisdiction, personal and territorial jurisdiction. It is likely to be the determinative clause where the jurisdiction of the court is concerned. The court cannot have personal jurisdiction over any defendant not falling within its subject matter jurisdiction. And that, we say, is also echoed within the Karafi judgment. Again, Mr. Fisher took you to that. But just to remind you where that is, it's tab 6 of the authorities bundle, 001196 in the electronic, and it's page 194 of the hard copy. And again, reiterating to show that what must be shown is a claim for a remedy by or against a party which falls within one of the 4 identified categories. Obviously, those are now 5. Insufficient to rely on the fact that a different party to that against which the claim in question is brought happens to be a party to the proceedings. So, similar sentiments. And then again, the importance of Article 5 reiterated in the IGPL case, which is at tab 8 of the authorities bundle. It's page 219. Where it starts, and if we can go to 01233, which is page 231 in the hard copy. And first of all, to paragraph 87 of that judgment. And 87 just reiterates that JAL was enacted to establish the DIFC and the DIFC Court of Appeal. It also defined the scope of this court's jurisdiction. And then again, paragraph 99. Again reiterated that the DIFC court's jurisdiction is determined solely by JAL. And that, of course, takes me back to where I started, which is going back to JAL itself. And JAL itself provides no basis at all for saying that 20.7 gives some kind of additional jurisdiction over a party in respect of whom the court otherwise has no jurisdiction. If for any reason the court was against us, we do also say in this particular case it wouldn't be desirable for Mr. Fadl to be joined. We have set out those submissions at length in our original skeleton argument, which, for your reference, is at page 001568 of the electronic bundle, or it's file 1, tab 18, page 190. And at paragraph 55 on that page, we dealt first of all 20.71, and I think it's not suggested that it's necessary for him to be added to resolve all issues in dispute. But we have also said that he doesn't either. It's not desirable for him to be added under 20.72. And our submissions on that run through over a number of pages. They run through all the way to 001573. And if I can draw your attention to paragraph 67, and it's 001572. And there we quote from authority that merely being a witness and merely having relevant evidence to give isn't sufficient for you to be joined in.
It's not desirable that he be joined in.
Well, in this case, we have a real difficulty with what's set as the reason why he must be joined in, because if the claimants are right, their case is that DTME are responsible for Mr. Fadl's actions. So if they're right in that,
why do you need?
You don't need second proceedings. You just need these proceedings to be heard and to succeed if the claimants are right. So we simply don't understand. In terms of whether he's a witness or not, that will be a matter for DTME to decide. But obviously, because he was the person who dealt with matters, certainly he was the partner in charge, one might question how the defence will be conducted without him being here. But ultimately, that's a matter for DTME.
Unless Mr. Fadl is worth a lot more than DTME.
Well, no comment on that, but that can't be a reason. That doesn't fall within the desirability grounds. So we say that we appreciate why the court wants to decide this as a matter of principle, and obviously it's important that guidance is given generally. But actually, on the facts, we say that the test isn't met in any event. And as I say, we are simply somewhat surprised that it's suggested that the action against DTME needs to have Mr. Fadl here, or it's desirable for him to be here. That shouldn't be an issue for the claimants.
The question is, as Mr. Fisher accepted, I put it to him, it's not necessary a claim, because he could be present for all the reasons you guys given. But if there is to be a claim against him, it's hard for you to say it's not desirable that it be heard at the same time and in the same place.
Well, we've raised particular issues that do arise in this particular case. For example, there are confidentiality issues that arise that he is subject to, etc. But I think the point is this: if the claim against DTME is a good claim, there's no need for a second settlement. So we don't.
I understand that desirability is what you're addressing at present.
Yes.
For my part, I find it quite difficult to see how that point really arises.
Well, we would say it isn't desirable for him to be tried here.
Well, if he's going to be tried here, and we have to work on a hypothesis, that the claimant wants to sue.
But
The idea there should be two separate sets of proceedings, Justice, on its face of its
well,
maybe it has to be, because the court has no power. I understand all of that.
because the court's exercising a wide jurisdiction, we don't accept the claimant can just come and say, I want to sue somebody.
No.
In my submission, the court needs to look at what's driving that or what's said to drive it. And we do say the court should regard with scepticism the suggestion that there will be two sets of proceedings. Because in my submission, this case has been commenced here. If it's a good claim, there is no need for a second set of proceedings. And we say that that is being used as a device to try and get him here personally in circumstances where it's not desirable, doesn't meet the tests. And it's interesting that today the thing that Mr. Fisher addressed you on was the desirability of him being a witness. Now that doesn't meet the desirability test or the necessary and proper party test. But anyway, I mean, these are very much secondary submissions in the event that we're not successful on our primary issue. But we do say very, very strongly on our primary issue that there is a very simple answer to this appeal, and that's to be found within JAL itself.
Can you help me with the meaning of desirable in the context of paragraph 27? Desirable. Do you have anything to guide? We need to decide what's desirable.
Well, again, because it's not, there isn't a great deal of case law on that, and it's a different word. So I think that if you look at the skeleton arguments below.
What is the equivalent word used in the CPR or any other civil law?
Well, what we've looked at is necessary and proper, because there's a lot of case law on necessary and proper, but desirable in my submission has a different meaning.
The rule itself gives you a clue, doesn't it? Desirable, so that.
Yes.
So that's the basic point, isn't it?
Yeah.
So if you've got common issues, is it desirable for the court to resolve the common issue between the existing parties to the current proceedings at the same time as resolving that issue between one or other or both of those parties and the new party? Now, there may be reasons why it's undesirable, because there's a better forum or whatever. But it's to enable the court to exercise its discretion in relation to balance of convenience and cost and expense and all those issues that arise usually in the context of foreign convenience.
Yes, no, that's right. An issue, the rule itself says there must be an issue connected to the matters and desirable to add the new parties so that the court can resolve that issue. But in my submission, it does give a pretty wide discretion to the court, looking at all the different issues that arise. So unless there's anything else that I can assist you with, those are my submissions.
Thank you. Is there anything you want to say, Mr. Bishop?
I can be very short. The court has our submissions on this issue of what is really an issue of circularity, almost like a loop that my learned friend has erected, and that we say it's quite unnecessarily inappropriate, because it's quite clear we would say that it's a misreading of the position for a defendant to be added to say that you can only get to E if you've already gone through A to D. With respect, cannot be right, for all the reasons we've articulated. And so that would be the first thing we would say. It also, of course, as we've addressed before, it would render 20.7 and indeed 21 really hamstrung. It would be a very limited application, and we will submit that can't be what was in the mind of those framing 20.7. And so it seems to us, with respect, that doesn't run either. So far as the point about desirability is concerned, well, we've set our stall out, and again, respectfully, we would say that we've actually set it out and fall within the language of 3.7. It's exactly the point. There are common issues there, and they need to be resolved. And of course, at the moment, from our perspective, from where we are, we obviously don't know. This is pre-first, so we don't know how the defendants are going to respond, and we're going to necessarily respond in that line. And so, of course, it's desirable that these issues should be dealt with together. And so we would say that that case is very clearly out as well. Unless I can assist the court further, that's all I was referring to say.
What about Ms. Day's strongest point, I would suggest, about the distinction drawn between DIFC regulations and rules of court in the JL itself? Does that mean that the rules of court can't qualify as a DIFC regulation for the purpose of Article 5AE?
Well, no, for reasons that we set out in open matter, we would say no, that the rules of court do constitute the DIFC regulation as we trotted through the various provisions. We would say that's clearly established. And even friends, construction, we would say respectively a very artificial constraint, and it actually doesn't take away she wants to go. So, although we would say with greater respect to her, yes, of course, we recognise the point she's making, not strong enough, and the rules of court are plainly within the category of the IFC regulation. Thank you very much.
Religion. Reserve decision. We'll reserve our decision and come back to you with the decision. I don't know when, as soon as we can.
Thank you.
So are there any complications which arise in relation to consequential rules? Self-evidently, if Ms. Day of course follow the event, and that would be that. If Ms. Day is wrong, are there? Presumably we'd have to make some consequential directions of some kind, would we? Service of defence and so on and so forth, I suppose, if nothing else. But also, are there any complications on costs?
Yes, I mean, I think, well, I'm not sure there'd be complications on costs. The directions would be somewhat complicated, not least we also have a limitation issue in relation to him being added back in, so that might need to be dealt with next, as it were.
Does this court have power to add someone in with the effect that the date of join that becomes the relevant date for Limitation Act purposes? You remember the long debate that used to happen in the UK about such things. It always seemed to me that was the easiest answer to it. Then the point of limitation could be argued as and when necessary on the basis of the date of joinder.
Yes, correct. But that might need to be determined before any defence. I
haven't looked at the rules to see if that's possible.
No. I confess
so really,
I
what
haven't.
you're saying is that we...
I think there will need to be some discussion. Yes.
The parties are going to have to make some further submissions as to where we go from there.
Yes.
Decision is. But if we're in favour of Ms. Day, there's really nothing else to resolve this thing. Thank you very much.
Okay.
All rise.